It might be it.
Worry about doom and gloom economic news, and you can have peace of mind that you'll receive your statement every month with no surprises. Would you like some more information? Just call 877-80-INVEST. That's 877-80.
Who's not an attorney needs to please mute yourself. I hear someone's television.
135. Do well by doing good.
We have people still arriving.
How much space?
Okay, I hear sounds. This is Judge Aho. Please mute yourself if you're not an attorney participating today. Everybody's welcome, but I need everyone to please be muted if you're not an attorney who will be participating in the hearing. We have people still arriving. We have people still arriving, but I'm going to go ahead and go on the record. Good afternoon. Welcome to all. My name is Judge Marianne Aho. We are here. It's 4:31 p.m. Please, if everyone could mute yourself, if you're not an attorney participating in the hearing. We are here on Amelia Island Sanctuary Property Owners Association at Nassau County and Riverstone et al. 23-384.
Excuse me, Your Honor. I can't. Excuse me, Your Honor. This is Cindy, the court reporter. I can't. There's people that are loud besides you.
Yes. So I'm very hopeful
What?
we can do this
Where have I been?
by Zoom,
I'm listening to starting the hearing.
but I can't have the hearing if we have people who are not muting yourself.
Yeah, make sure you're muted.
If we're not able to do that, we'll have to schedule and we'll have to do this in person in a courtroom. This is a courtroom. This is a Zoom courtroom, and I need silence. So please mute yourself if you're not an attorney participating.
That's not us. I don't know who that is.
Someone named Melinda, mute yourself. Someone named Judy Easterly, please mute yourself. Someone named Melinda, please mute yourself. Okay, wonderful. I can hear now. That's great. So we're on the record at 4:33 p.m. This is Amelia Island Sanctuary Property Owners Association et al. Versus Nassau County and Riverstone Properties et al. 23 CA 384. And we're here for hearings on defendant Nassau County's motion for summary judgment as to counts 2 and 3. Defendant Riverstone Properties motion for summary judgment filed August 5, 2024, and plaintiff's motion for summary judgment on Burt Harris Act affirmative defenses filed January 14, 2025. And I did receive correspondence today from Mr. Henderson with copies of a motion to strike Riverstone Properties reply and plaintiff's motion to continue hearing. I would like for counsel to please enter your appearances, and I would ask again, if everybody who's here who's not an attorney participating could please mute yourself so that we can hear clearly and Madam Clerk, Court Reporter can keep an accurate record.
Can you see?
Counsel, if you would please state any other additional motions that are set for today and could please enter your
Your Honor, this is Reese Henderson on behalf of the plaintiff, Amelia Island Sanctuary Property Owners Association. And I'm entering my appearance, and I believe you've covered the motions that we're here on today.
Very well.
Your Honor, Attorney Jeffrey Hines and Jay Bartlett on behalf of Nassau County. I heard two motions set today. I believe there are three. Let me say this, Your Honor. I had to make an unexpected trip out of town due to a critically ill relative. I'm not at all familiar with this AV equipment. So forgive me if you can't hear me, or if you would just let me know.
I was going to put one underneath my.
Okay, so I'm seeing people are asking me if I can mute all participants. Technically, I could, but I'm choosing not to because that would mute the lawyers, and I need to hear from the lawyers. So, but
If I could make a suggestion, Your Honor, I think if you mute everybody and then you could individually unmute the attorneys.
Let's give it a try. Can't hurt it.
Okay, that might work.
Let's give it a try. Muting everybody, and then the attorneys can unmute yourselves.
Okay.
Okay, I think that worked. Wonderful.
Okay.
Your
Awesome.
Honor, again, on behalf of Nassau County, Attorney Jeffrey Hines and Jay Bartlett, my understanding is that there were three motions to be heard today.
Yes. And they're all listed on the defendant's second amended joint notice of hearing filed 2/26 of 25 at 3:17. Thank you.
Your Honor, and this is Fred Franklin along with Christy Russell and T.R. Hainline on behalf of Riverstone Properties.
Very well, welcome. There's people continuing to arrive. If anybody is driving a vehicle, you need to park. It doesn't bother me if someone attends who's in a vehicle, that's okay. But it is not okay for you to attend this Zoom hearing if you are driving. If something were to happen and I allowed you to attend a Zoom hearing driving, there would be issues that we do not want to have happen. We want everyone to be safe. So please, if you're driving, pull over or drop off the Zoom. So counsel, we have 2 hours. I appreciate your courtesy in moving this to the afternoon. I have my mother is catastrophically ill, and we're working very hard to get the right team in place. And so there were appointments that came up suddenly that just my sister and I had to be there. So I appreciate your courtesy, but you do have my full attention. I am fully prepared. So I was thinking it might make sense to address the motions filed by Mr. Henderson first. Mr. Henderson, why don't you go ahead with your 2 motions that you sent as the cover letter of today's date, February 27, 2025. I did receive the information from my JA that there is opposition to the motion to continue, but I think we should address the motion to continue. I have reviewed it. So, sir.
Thank you, Your Honor. And I'll try to be brief. The motion to strike, I think, is pretty straightforward. There was new argument raised in the reply that was filed last week, 6 days before the hearing, and under the summary judgment rules, that's simply improper. And so I'm asking the court to strike the reply and not consider the argument they raised for the first time in their filing last Friday afternoon about 2:30. With regard to the motion to continue, this harkens back, Judge, to when we were before you back in November on the defendant's motions for protective order. And you recall that the discussion back then was concerning whether the plaintiffs will be entitled to discovery about the defendant's interpretation of the settlement agreement. And in response to that, or in support of their motions for protective order, we had Nassau County saying that the parties to the settlement agreement each think the language of the settlement agreement is clear and ambiguous, and therefore no parole evidence is admissible. We have Riverstone in its motion saying, it's on page 1 of the Riverstone motion for protective order, that the interpretation of the settlement agreement is a matter of law for the court. And on page 9 of Riverstone's motion for protective order, it says that the settlement agreement is a contract between Riverstone and the county, and as such, a party's own interpretation of a settlement agreement is not relevant, except in the limited circumstances where a party asserts that a settlement agreement is ambiguous, such that parole evidence is admissible. in their filings last Friday, Your Honor, in addition to the reply, there was a response filed to our motion for summary judgment. In those responses, Riverstone, for the first time, 6 days before the hearing, and I will tell you as a practical matter for me, more like 3 days before the hearing because it filed on a Friday afternoon, finally discloses with respect to some of the paragraphs of the settlement agreement about which we sought discovery, is now telling us how they interpret that language in a way that is not obvious from the express language itself. And so what we are essentially getting here is parole evidence by another name, because they're now supplementing the actual language of the agreement. And I pointed to 3 examples. One concerned paragraph 6 of the settlement agreement, and this is contained at pages 11 and 12 of Riverstone's response in supporting factual position to plaintiff's motion for summary judgment on Burke-Harris Act affirmative defenses. And in relation to that paragraph 6, Riverstone states that in other words, the settlement agreement ensures that permanent protections which were provided in the settlement agreement will be permanently eligible for replacement credit.
Wait. I'm just going to slow you down, Madam Court Reporter.
I'm sorry.
Zoom. If we were in person, I don't know if it would be an issue, but on Zoom, maybe just a little slower would be great.
Well, let me just try to paraphrase then to make this simpler. But the relevant quote for the record is on pages 11 to 12 of Riverstone's response. But basically, what they're saying is, well, here's what this paragraph 6 really means, and they even go on to say that it would allow tree protection standards to be expanded. Now, when you look at paragraph 6 of the agreement, it doesn't say anything about expanding tree protections. In fact, it says, and I quote, it says, the property shall not be subject to any amendments to the LDC, comprehensive plan, or other regulatory documents that alters the tree protection and replacement standards for unincorporated areas of Amelia Island. So, in fact, our contention is based on the express language. It freezes it in ether, and it can never change. Well, now they offer this gloss that we have never been privy to before. Another example is quoted on page 20 of their response to our motion for summary judgment, and this relates to paragraph 8 of the settlement agreement, and they offer a gloss that the provision for up to 150 residential units actually means up to 150 residential units pursuant to the density calculation methodologies provided in the comprehensive plan and RG2 zoning. Again, that doesn't appear anywhere in the settlement agreement language, but that's what they now want us to believe based on, I'm not sure what, but they're based on representations of counsel that that's what it means. But there's nothing in the settlement agreement that says that. And finally, with respect to paragraph 9D, they state, and this is in their reply in opposition to our motion, our response to the motion for summary judgment, is that pages 7 and 8 of their reply, which I have asked you to strike, but if for some reason it survives, they contain the statement that plaintiff divorces this statement from its purpose in the settlement agreement. And they go on to tell the reader what Riverstone thinks the purpose of that agreement is, or that the provision of the agreement. And again, that's nowhere in the document itself. And the significance of this, Judge, is that this is exactly what I feared would happen when we appeared before you on the motion for protective order, is that we would have no ability to ask Riverstone how it thought that this agreement actually operated. And then right before the hearing, when it's most tactically advantageous to them, now they decide to disclose this. And this was particularly, the case with our motion, with our request for discovery. If you look at our original Schedule A that was attached to our response to the motion for protective order, we had a topic 12, which asked for the practical effect of paragraph 6 of the settlement agreement as applied to any future development of the property. Well, they're now telling us what they think the practical effect of paragraph 6 is. We had a topic 16 on the practical effect of paragraph 8 of the settlement agreement as applied to any future development. They're now telling us what they think that is. And finally, we had a topic 22, the practical effect of paragraph 9D of the settlement agreement as applied to any future development. Now they're telling us what they think that is. So we are put in a position that's very prejudicial, where on the eve of the summary judgment hearing, they're able to provide what they believe the settlement agreement means as a way to avoid our comp plan consistency challenge. That in a way that we've not been provided any opportunity to probe into that to see if that is in fact how Riverstone and Nassau County understand this, and there was some discussion that led up to this understanding, or is this just Riverstone taking tactical advantage of the fact that we haven't had any discovery to say, well, here's what we think it means, and by the way, you don't get to have any discovery about that. So we think that this is very prejudicial, and if they meant what they said in their motions for protective order, we wouldn't be having this conversation because they would be relying upon the express language of the agreement itself. But instead, Riverstone has gone beyond the express language, and we now find ourselves in the position I feared that we would be in. And so my client is prejudiced, and I think that in light of that, and again, I say this reluctantly because I've spent today preparing for this hearing. I really would prefer to resolve this, but the reality is my client is prejudiced, and for that reason and that reason only, the hearing should be continued to give my client the opportunity to obtain discovery on these very points and other points relevant in the settlement agreement. But certainly, I would submit that Riverstone has opened the door, at a minimum, as to their interpretations of paragraph 6, 8, and 9D. And at a very minimum, we should be provided discovery as to their interpretations as stated in their response of those provisions. So I'll stop there and I'm available for the court. Thank you.
Thank you, Mr. Henderson. I'll hear from counsel.
Your Honor, very briefly on behalf of Nassau County, for the record, Attorney Jeffrey Hines. Can you hear me okay?
I do.
Thank you. Again, very, very briefly, just 3 points. One, these are essentially the same grounds that Mr. Henderson used in his motion to continue on November 13th, 2024, at which point the court gave him additional time to do discovery, but he chose not to. The second argument is that based on my limited review of Mr. Henderson's motion, again, I'm on the road and haven't actually seen a hard copy of it, but it sounds like he's concerned about our arguments of counsel and how counsel views the settlement agreement and not statements of fact. And then the county's third position is that Mr. Henderson's motion to continue is not directed at all at the county's motion for summary judgment, which, as I mentioned last time, is on separate grounds. So we would ask that regardless of what you decide to do with with Riverstone's motion for summary judgment, you allow Nassau County to proceed on their motion. Thank you.
Thank you. I did see, Mr. Hines, that Nassau County did file a notice of joining Riverstone's motion for summary judgment in December of 2024, correct?
Yes, Your Honor, that is correct. But we also have a standalone motion, which we're prepared to move forward on this afternoon. Thank you.
Understood. Thank you. I'll hear from counsel.
Your Honor, Christy Russell on behalf of Riverstone, and I will respond to the motion that was filed today to continue. I'll respond to the motion to continue first, Your Honor, and then very quickly address the motion to strike. Does the court have a copy of the settlement agreement readily available? I know it's probably in the note one has submitted to the court. I believe it is in Riverstone's motion in connection with our memorandum in opposition to the plaintiff's motion for summary judgment on the affirmative defenses.
You're probably right. So tell me the name of the pleading motion that I'm looking for.
No, it's just a copy of the settlement agreement, Your Honor.
Which you're saying is an exhibit to one of the motions, is that right?
Well, Your Honor, actually, it's Exhibit D, plaintiff's second amended complaint. So if one of the is in it,
I do have the second amended complaint.
Okay, and Exhibit D to that, D as in dog, I believe would be the settlement agreement between Riverstone and the county.
Yes.
Okay.
Yes. Okay, so I'm at Exhibit B, like boy, C.
D as in dog.
Yes, yep, it's right here. Settlement and offer and agreement.
Yes.
Yes, I have it right here. April 24, 2023.
Yes, Your Honor, and that is a settlement agreement that is the subject of this lawsuit.
Yes.
Okay, so I've only referred to that because in order to respond, I'm going to need to just refer to some provisions of the settlement agreement. So the majority of the motion to continue is directed not to Riverstone's original motion for summary judgment on the second amended complaint, but is directed to the memorandum in opposition that we filed to the plaintiff's motion. The plaintiff's motion was directed to the affirmative defense, the same defense argued by Riverstone and the county, that this entire lawsuit essentially is barred because the parties were entitled to move forward under the provisions of the Burt Harris statute. that we complied with that statute in entering into the settlement agreement, that the Burt-Harris statute governs that settlement agreement, and that therefore these other claims that were brought by the plaintiffs were not valid as a matter of law. That's the affirmative defense that was pled by the county and Riverstone, and that is what the plaintiff's motion for summary judgment, their affirmative motion, was directed to. We filed our response on Friday. We filed it on Friday because that was the time frame within which we were permitted to file it under the new rule. As you recall, we had a hearing very recently where the court directed that the hearing would take place in a time frame that was a little bit shorter than what's contemplated under the rule. So we did file that on Friday. We have not filed in support of that response any affidavit on behalf of our client, Riverstone. We are not supporting that response with any factual allegations of our client. Our response to the motion is based on the following things. It is based on the Burt-Harris statute itself, and particularly subsection C and D, which governs settlements. It is based on the language of the settlement agreement between the parties. It is based on the Nassau County Land Development Code, which is referenced throughout the settlement agreement. It is not attached to the settlement agreement, but it is law. It is the law of Nassau County, and it is referenced and interrelates to the settlement agreement. And then the last thing that we refer to is the comprehensive plan of Nassau County, and we do that because that's the basis of the plaintiff's argument. One of their arguments is that the settlement agreement does not comply with the comprehensive plan. And we'll go into that. Mr. Franklin will go into that later in connection with the motions for summary judgment, but that also is something that we reference. So all of the arguments that were presented in response are arguments that relate to Riverstone's legal interpretation of the settlement. That is what we are arguing to the court. The argument on plaintiff's motions based on those affirmative defenses is Riverstone did not comply with the Burt-Harris statute because the settlement agreement itself is not in compliance with that statute. We are arguing to the court based on the language of the settlement agreement, based on the language of the Land Development Code, that the Burt-Harris statute is in compliance. Now, some of that goes into the interrelationship between the Land Development Code and the settlement agreement. And just by way of example, Your Honor, just going to, let me start with page 5 of the motion to continue. And
I'm sorry, page 5 of what?
On page 4 of the motion to
To
continue.
page 5 of the motion to continue.
Thank you.
Where counsel says Riverstone.
Ms.
now-
Russell, all of a sudden your volume has dropped too low. That just happened.
Oh,
I think, Mr. Henderson, if you're rustling papers and things, that we can hear that. I can hear that.
Your Honor, can you hear me at this point?
I can, yes.
So just going to page 4 of Mr. Henderson's motion to continue, just by way of example, says Riverstone now helpfully explains why it thinks this provision does not violate the comprehensive plan. And I'm sorry, Your Honor, I just lost my place for a moment here.
That's okay. Take your time.
Okay. Okay. So no water? Do you want water?
Okay, Your Honor. So I'm sorry, going just to page 4, the provision that Mr. Henderson cites, which was at page 11 and 12 of our response, where he's talking about, he says, in other words, the settlement agreement ensures that permanent protections which were provided in the settlement agreement will be permanently eligible for replacement credit. Talking about the tree mitigation provision of the settlement agreement. So if I could just direct the court's attention to section 6 of the settlement agreement. Section
page 5, yes.
Yes, so just by way of example here, section 6 specifically says on page 5 of 15, in Article 37, Section 3702 of the Land Development Code. And then it talks about the property should not be subject to any amendments to the Land Development Code, Comprehensive Plan, or other regulatory documents that alters the tree protection and replacement standards for the unincorporated areas of Amelia Island. Then it again references Article 37 and specifically sections 3702K of the Land Development Code. That's just an example of the types of provisions that are set forth in the settlement agreement that have an interrelationship between the Land Development Code and the settlement agreement. So section 3702, which is referenced there, is actually entitled Unincorporated Amelia Island Tree Protection and Replacement. 3702L is Replacement Trees Requirements. 3702K addresses preservation credits. And section 6 of the settlement agreement says, consistent with Article 37, trees preserved within buffers and beach access areas are eligible for tree preservation credits. So, I just offer that by way of example to the types of arguments that are being made there. We are not asking the court to refer to anything other than the settlement agreement, the Land Development Code, the Byrd-Harris Act, and at the comprehensive plan at times, because that's what forms the basis for the plaintiff's claim. If we were to ask the court to consider something outside either the law or the record before the court, then I think Mr. Henderson is correct that the court would not consider that as parole evidence. But really, I think what's being complained about here is the specific arguments that we are offering as to how the court should interpret the settlement agreement and the Land Development Code, Your Honor. And that is a matter of law. It is a matter of interpretation of local government law and the settlement agreement itself. The court, of course, as the construer of the settlement agreement, may accept or reject Riverstone's interpretation, but those are matters of law for the court. So for those reasons, Your Honor, we would request that the court deny the motion to continue on the ground that there has been any submission by Riverstone of any matter of fact that has anything to do with the motion for protective order that was entered by the court previously. Again, Riverstone has not filed any evidence that we're asking the court to consider affirmative evidence, such as affidavit from our client. Everything is a matter of law. And Your Honor, I can go just very, very quickly to the motion to strike the reply, unless the court wants to take up those motions one at a time.
Why don't we finish argument on the motion to continue first? Okay, I'll hear from you, anybody else who wants to be heard on the motion to continue? Nothing else, Mr. Henderson?
Oh, sorry, Your Honor. I was, I wanted to make sure you were talking to me. Just very briefly, Your Honor. We've covered it pretty much, but again, I didn't hear anything that said, from Ms. Russell that explains where they get that the tree protection standards. That's paragraph 6 of the settlement agreement that we were just looking at has language that allows the tree protection standards to be expanded. We're all looking at paragraph 6. It's, 3, I think it's approximately 3, maybe 4 sentences total. There's nothing in there that says anything about expanding tree protection standards. So that could only come from some sort of understanding that Nassau County and Riverstone reached about this, that's how they understood this would work. Because there's nothing, just looking at the face of this agreement, you could not draw that conclusion based upon what they've stated here. So, that's either an argument with no support, or it's based upon an understanding that, again, that we haven't been privy to. And this is an example of what I was talking about, where they're going into, going beyond the expressed language of the agreement to try to assure Your Honor that, well, no, what this really means is that we're going to comply with the density calculation methodologies, even though the agreement doesn't say that. So that's the concern, is there some understanding, and certainly appears to be, between Riverstone and Nassau County that we're not privy to. So that pretty much sums it up, Your Honor.
Thank you, sir. Mr. Hines, any other argument on the motion to continue?
No other argument from the county, Your Honor.
Ms. Russell, any other argument on the motion to continue?
Or just very briefly, to respond to what Mr. Henderson just said. So section 6 of the settlement agreement plainly says that consistent with articles 37 and then provision 7, section 3702K of the Land Development Code, existing trees preserved within buffers and beach access areas are eligible for tree preservation credits. That's not a secret understanding. Section 6 of the settlement agreement also says the property, quote, shall not be subject to any amendments to the LDC comprehensive plan or other regulatory documents that alters.
Wait, your voice trailed off. That alters?
I'm sorry, that alters the tree protection and replacement standards. So what's being argued there is an interpretation of the settlement agreement. The court, of course, is free to reject or accept that, but we're not offering that as a statement of fact. That's our interpretation of the settlement agreement in conjunction with what the Land Development Code says. It's clearly set forth in our response, which we tried to respond to all of these allegations with regard to whether or not there were inconsistencies between the settlement agreement and the comprehensive plan. We had to go into great detail with land development regulations and provisions of the comprehensive plan to do that. But Your Honor, those are matters of law.
Anything else before I rule on the motion to continue? No. Okay, after carefully considering plaintiff's motion to continue hearing on motions for summary judgment that was filed midday today at 11:58 a.m., I have reviewed the motion, listened carefully to the arguments of counsel, and I'm respectfully denying the motion. So the hearing will go forward. Who can take charge of preparing a short order saying that that was denied? I understand we have the luxury of a court reporter, but I'd like to have an order. Is that something, Ms. Russell, you can place on your to-do list?
Yes, Your Honor, I will do that.
Okay, now, Mr. Henderson, when you made your argument on the motion to continue, you did also talk about the motion to strike, but I do want to focus on the motion to strike right now. Is there anything else you wanted to say about the motion to strike?
No, I referred the court back to the written motion that we filed in my earlier statement.
Understood. So, Mr. Hines, did you have anything you wanted to say about the motion to strike?
No, Your Honor.
Okay, Ms. Russell, is there anything else you wanted to say about the motion to strike?
Yes, Your Honor, if I could, very briefly, just looking at the motion to strike, if I could direct the court's attention to paragraph 3 of the motion.
To paragraph what?
3, Your Honor, page 2, paragraph 3 of the plaintiff's motion to strike.
Yes.
Okay, I think this is really the heart of the motion. In particular, Riverstone raises an entirely new argument. Section 163-3215 allegedly does not.
So, Ms. Russell, I don't know what it is, but the volume of your microphone is kind of going in and out.
Your Honor, if I could just say, I don't mean to like throw Mr. Henderson under the bus, but I think when he's not on mute for some reason, it's causing an issue.
Okay, so he's on mute now. We're all working together with one another. That's fine. Ms. Russell, you may proceed.
Your Honor, on page 2, paragraph 3 of the motion to strike, I think this is the heart of the motion. In particular, as stated by the plaintiffs, in particular, Riverstone raises an entirely new argument that section 163-3215 does not apply to Burt Harris Act settlements. And the argument is, this argument is not identified or briefed in Riverstone's motion. Your Honor, respectfully, I do not know how that argument is being made. The main thrust of our argument is that the Burt Harris statute governs the settlement agreement in this case. And so all 3 of the claims as originally pled by the plaintiffs failed as a matter of law because those claims cannot be brought when the Burt Harris statute itself, as a separate and insular statute with its own settlement procedures, governs Burt Harris Act claims. So I'm just very briefly, Your Honor, if the court has Riverstone's motion for summary judgment, in our bench book that we submitted to the court, you asked that we please strike out the portions of our motion that were not relevant to the court.
Right.
And so I did just that. I put an X through those portions that were no longer relevant to the court. But I just want to point out what is in our motion, because I think the crux of the motion to strike is that we are raising a ground for summary judgment that we did not previously raise before. And so I do need to just reference that motion if the court has the motion handy.
I have all the motions.
Okay. So going to Riverstone's motion for summary judgment, which was the first motion filed on August 5th. If the court goes to the very top of page 2, that really summarizes our argument. And it is that the plaintiffs are ignoring, we say right there, the plaintiffs have attempted to characterize the settlement agreement as a variance and a rezoning and a legal contract, a development agreement, and a development order. And that they then argue the settlement agreement violates laws applicable to those things, ignoring that the settlement agreement is expressly authorized by the Burt-Harris Act. And if I could just go down just a little bit further, we then on page 5 go into great detail, and Mr. Franklin's going to talk about this, but we go into great detail on the Burt-Harris settlement procedures. Then we go to argument 4A. And argument 4A of our motion is that the claims set forth in the second amended complaint fail as a matter of law because the settlement agreement is a legislative action authorized by the Burt-Harris Act. Argument 4A, which we are still asking the court to consider, applies to all three. And we say right there at the outset that because the Burt-Harris Act applies, all three, count 1, count 2, and count 3 fail as a matter of law. And we say even, under chapter 163.32.15, that fails as a matter of law because this is governed by the Burt-Harris Act. If we keep going through the motion, Your Honor, on page 9, toward the bottom of that page there, the last paragraph that begins on page 9, we say here the settlement agreement expressly cites as authorization sections 70.014C and D of the Burt-Harris Act. That's the provision that is so important to the settlement agreement. And then we cross out the portions of the motion that are no longer relevant, which relate to counts 2 and 3, which the plaintiffs did withdraw. But then, Your Honor, we get to page 16, which is where we talk about count 3. And we say the court should enter summary judgment on count 3 on the additional grounds that the settlement agreement is not a development order, does not alter use density or intensity, and is not consistent with the comprehensive plan. So then we go to count 3, and what we're saying there is, Your Honor, even if you don't agree with us that the Burt-Harris Act completely bars all of these claims, in addition to that, on count 3, we're saying if you even look at 163.32.15, it's not a development order. It doesn't alter use density or intensity, and it is consistent with the comprehensive plan. So then we go into the specifics, but our overarching main point in our summary judgment motion is that this is a Burt-Harris Act. And specifically, we cite a case the court will hear a great deal about today, which is United States versus City of Homestead, which I think is a seminal case on how parties are to bring requests for relief under the Burt-Harris Act. And it is not through a chapter 163.32.15 statutory claim. And that is something that Mr. Franklin will argue more today. But in response to our motion that was filed I'm sorry, Your Honor, I have a lot of documents up in front of me.
Take your time.
Thank you very much. So in response to our motion that was filed by the remaining plaintiff in this case, and this is why we filed, one of the reasons we filed the reply, Your Honor, in response to that motion, you go to page 4 of the response that was filed by Mr. Henderson. He then offers, he says he's withdrawing counts 1 and 2, but then he says he's leaving count 3. And he says, unlike the declaratory relief sought in count 1, the relief sought under count 3 is pursuant to a statute specifically granting standing to a class of plaintiffs to challenge development orders for consistency with the local government comprehensive plan. He then says the City of Homestead, which we cited throughout our motion, did not address such a claim, and defendants have cited no other authority purporting to bar or limit chapter 163.32.15. So our reply, Your Honor, we filed it for 3 reasons. One was to address this very specific argument as to whether or not the City of Homestead case bars Chapter 163, 3215 claims in this context. So that was one of the legal arguments that we raised in our reply. But the other grounds for our reply, which I think Mr. Franklin will go into in more detail, are we felt there was an improper attempt to create issues of material fact based on improper legal argument and based on an affidavit that was filed that we believe contradicted earlier deposition testimony. So all those reasons together, we reviewed Rule 1.1510 as well as this court's procedures, and we didn't see anything that would preclude the filing of a brief reply. Again, in terms of the legal arguments, we filed it to respond to this very specific argument on page 4 of the response as to the continued viability of count 3. But we did not raise any new ground. The ground for our motion is the same, which is first that the Burt-Harris Act governs this claim as a matter of law, and 2, that even if the court does look to the specifics of 163-3215, there are specific reasons applicable to that statute why that relief is not appropriate, Your Honor. So for those reasons, we would ask the court respectfully that you do consider the brief reply memorandum that we filed.
Thank you, Ms. Russell. Anything else, Mr. Henderson, on this motion to strike? I think you're on mute, sir.
Thank you, Your Honor. I forgot that I was on mute. Yeah, just briefly, Your Honor, it's very interesting to hear Ms. Russell, because, looking at the original motion, there's a reference to the City of Homestead decision, and that was used as an attack on all the accounts of the complaint. And then when they get to the specifics of count 3, they're talking about the specific elements of our claim, whether it's a development order, whether it materially alters the use density or intensity of use. And yes, the thrust of their argument is that this is authorized under Burt-Harris, but what you don't have is this comparison of, for example, at top page 4 of the reply, when reconciling statutes, the more specific will control over the general.
Okay, Mr. Henderson,
K-12.
Mr. Henderson, you're all of a sudden breaking up. So can you just just a little? It's just.
Can you hear me okay now?
Yes, yes.
Okay, I understand. Well, I was referring to page 4 of their reply, where they're talking about things like, when reconciling statutes, the more specific will control over the more general. So now they're going into sort of detailed comparison of 163.
It's clicking in and out. It's clicking in and out, and it wasn't doing that before. So if you just back up a few sentences, I am listening very intently.
Yeah, I hope this will work. Can you hear me now?
I do. I hear you great.
Okay, so page 4 of their reply, they're talking about the comparison of chapters 163 and chapter 70, which is the Burt-Harris Act, and they're talking about, well, which statute should prevail. All of this is argument that wasn't raised in their original motion. They did cite the City of Homestead decision, and we responded to that and said, well, City of Homestead doesn't address chapter 163. Well, they didn't reply and just say, well, actually, we think City of Homestead does address chapter 163. They go into this whole analysis as to whether 163 even covers Burt-Harris settlements at all, and that was not an argument advanced in their motion. So if they wanted to advance that, they filed their motion 6 months ago. If they wanted to make that argument, they could have made it at any time in the last 6 months. They should not be allowed to bring the argument up 6 days before the hearing.
Anything else, Ms. Russell?
A plain reading of our motion that we absolutely argued from the outset that the Burt-Harris statute controls, and that as a matter of law, all of the counts complaint. That's the entire first section of the motion.
Excuse me 1 second. Could you, Ms. Russell, Mr. Henderson, can you please mute again? Sorry to do that to you. Okay, can you start over? I'm sorry, Judge.
No, I was about to say exactly the same thing. Okay, if you could start over, please, Ms. Russell.
Yes, Your Honor. I don't agree with Mr. Henderson's characterization at all. The entire first section of our motion for summary judgment was based on the argument that Bert Harris controls the settlement agreement and the court's consideration of the settlement agreement, and that those claims as a matter of law are barred because the settlement agreement doesn't apply. I think what Mr. Henderson is saying, that I did not make a specific argument as to statutory interpretation or reference all of the cases in my original motion that I put in the reply. And that's because he raised a new argument in his response as to whether or not the city of Homestead made his count viable. And so that, that may be a nuance of argument, but that's no different than if we came to the court at a hearing and argued some specific case law in response to what he's filed in opposition to our motion for summary judgment. It's not a new ground for summary judgment. It's simply a reply to his argument.
Anything else on the motion to strike before I rule?
No, Your Honor.
Okay. After carefully reviewing the motion to strike and hearing argument and being familiar with the motions that are referenced in the papers and in the arguments, I'm respectfully denying the motion to strike and asking Ms. Russell to draft a proposed order. Now, let's be very practical about the clock. It's 5:16. So we have spent 45 minutes of our allotted 2 hours on the 2 motions filed today at 11:58 a.m. in or about by Mr. Henderson, which I understand why he brought the motions. I respect that, but on a practical level, that's taken 45 minutes of our 2 hours. And I have a deputy who stayed late with me until 6:30, but I cannot ask him to stay past 6:30, even though I'd be happy to keep working. So we have until 6:30. We have an hour and 15 minutes. So I'll ask everybody what your thoughts are. Maybe we should work on Mr. Hines' motion about Bert Harris defenses. What do you think? I mean, do you want to go in the order that they're listed in the notice of hearing? And if we don't finish, bifurcate, what do you want to do?
For the record, Attorney Jeff Hines on behalf of Nassau County. I like that idea. Let's do the county's motion first.
The county wasn't really a part of the 45-minute discussion, so it seems fair if theirs goes first. Ms. Russell, do you have any objection?
No, Your Honor.
Okay, so that's what we'll do. Mr. Henderson, is that okay with you?
Just so I understand, Your Honor, which motion is Mr. Hines going to be arguing?
Which one do you want to start with, Mr. Hines?
Your Honor, the county's motion for summary judgment as to count 3 of the plaintiff's complaint.
Any objections?
That's fine, Your Honor.
Okay, I'm ready to listen.
That's fine, Your Honor. Thank you. I'll mute myself.
May it please the court, again, on behalf of Nassau County Attorney Jeffrey Hines. Can you hear me okay, Your Honor?
Yes.
Okay. Do you have the county's bench book?
I do. I have it right here.
The slender one.
Yes, it is. I have it right here.
Okay, so we're going to start with tab A. Tab A has 5 subtabs. Tab A is the county's motion for summary judgment as to count 3. Your Honor, in this motion, the narrow issue before the court is whether the settlement agreement constitutes a development order under 163-3215. So the plaintiff's count 3 sounds only in violation of 163-3215. And I'm going to walk the court through construction of that statute to show you why it's important to first ascertain whether the settlement agreement is a development order under the statute. And then I'm going to argue that it's not a development order, and as a result, the plaintiff's claim fails as a matter of law. And I just want to mention in passing again that the court can rule on Nassau County's motion and not rule on the other 2 motions for summary judgment in front of it. This is an independent grounds. Okay. So let's, since it's a statutory cause of action, let's start with the statute, which is at tab A2. Okay, and there's some highlighting there, and I'm just going to read the highlighted portion because that under sub 3, because that is the nub of what we're arguing today. Any aggrieved or adversely affected party may maintain a de novo action to challenge any decision of such local government granting or denying an application for, or to prevent such local government from taking any action on, and here's the key, a development order as defined in 163-3164, and then it goes on the basis that the development order materially alters the use, density, or intensity of use of a particular piece of property. So unfortunately, there's like a cascading rabbit hole that we have to go down to figure out exactly what a development order is, starting with 163-3164, which is where 163-3215 points us. So the next tab, tab 3, is 163-3164. And we see there that there are 3 definitions. And we're going to start with development order because that's actually going to lead us to the other 2. So in sub 15, the statute defines development order as any order granting, denying, or granting with conditions an application for a development permit. Well, what's a development permit? Well, thankfully, the statute has a definition for that too, and that's in 16. The development permit includes any building permit, zoning permit, subdivision approval, rezoning, certification, special exception, variance, or any other official action of local government having the effect of permitting the development of land. So you see here, the key is whether or not the action permits the development of land. That's the final criteria. So what is the development of land? We don't know, but we do have a definition of development immediately above in sub 14. Development, God bless the drafters, has the same meaning as in 380.04. So yet another statute, but this is where the road ends. So on tab 4, if you just turn the page, Your Honor, we will see our destination. What is development? The term development means, and then I've boxed 2 gerund phrases, okay? The carrying out of any building activity or mining operation, that's 1. The making of any material change in the use or appearance of any structure or land, that's 2, or the dividing of land into 3 or more parcels. So to figure out whether or not the settlement agreement is a development order under 163, 3164, 65, it needs to be one of those 3 things. It either needs to grant the carrying out of any building activity or mining operation, the making of any material change in the use or appearance of any structure, or the dividing of land into 3 or more parcels. The settlement agreement does none of these. Okay, so let me just walk through those 3 things real quick. Give me 1 second. So the first is carrying out any building activity or mining, and here I'm in the unenviable position of having to prove a negative, Your Honor. So at some point, I think that we're just going to have to roll up our sleeves and look at the settlement agreement. But for the purpose of my argument, because we're so short on time this evening, our argument is that the settlement agreement does not authorize the carrying out of any building activity or mining. The settlement agreement really, all it does is it sets some parameters for the agreement. It doesn't say you can go out and turn dirt, if you will. Nor does the settlement agreement make a material change in the use or appearance of the structure of the land. The settlement agreement, first off, the land is vacant, so there's no structure to modify. And second, it doesn't actually make any material change in the appearance of the land at all. It doesn't say you can go out there and cut down trees. It doesn't say you can clear. It doesn't say you can turn dirt. And then finally, it certainly doesn't divide the land into 3 or more parcels. Okay? That's just not in the settlement agreement. Mr. Henderson has an argument that maybe it divides it into 2 parcels, but he's not right. But even if you were, 2 parcels isn't enough under the statute to constitute a development order. So that's basically the end of our direct investigation into whether or not the settlement agreement is a development order under 163.32.15. Just want to make a few more points. Going back to those 2 phrases that I boxed in 380.04, which is at tab 4, the gerund phrases that I talked about. I believe what we're going to hear from the plaintiffs is that they're very concerned about what might happen under the settlement agreement. But the legislature is very specific in 380.04 in choosing gerund phrases. Gerunds are action, right? So the settlement agreement would actually have to cause the carrying out of building activity or the making of any material change in the land, not planning for it or in the future that might be approved. It actually has to cause that to happen. That's one. And then the second of plaintiffs' arguments that I want to address before rebuttal is that I believe what we're going to hear the plaintiffs say is that the settlement agreement materially alters the use, density, or intensity of the Riverstone property. And I just want to point out to the court, if we go all the way back to tab A2, which is where we started, at 163.32.15, if we go all the way or go down to sub 3, which is highlighted, if you remember, I parsed that into 2 bits. So the first bit is that we've got to have a development order, and I'm reading from the 3rd highlighted line, on the basis that the development order materially alters the use, density, or intensity of use on a particular piece of property. So I'm going to tell you, and I can go into granular detail here, that it does not materially alter the use, density, or intensity. But the county's primary argument is that we don't even get there, because first you've got to have a development order. We don't have a development order. So we don't have a development order, and nor does it alter the use, density, or intensity. And let me just cruise through those fairly quickly. Your Honor, first, the use of the property remains the same. The settlement agreement does not change the authorized uses. The property remains under the medium density residential land use category and RG2 zoning. That's not changed. And those zoning categories, they already permit single family, duplex, townhouses, and multifamily residential uses, both before and after the settlement agreement. So the use remains the same. So let's talk about the density. The density also remains the same under the settlement agreement. It does not increase density beyond which was originally allowed under the MDR land use category or the RG2 zoning. Before the settlement agreement was put in place, the property was allowed up to 150 residential units. And after the settlement agreement, that remains exactly the same, up to 150 residential units. And the density calculations are still going to be subject to future regulatory review under the comprehensive plan and the LDR. So that's 2. Number 3, the intensity remains the same as well. The plaintiffs have argued that restoring the maximum building height to 85 feet constitutes an intensity change. But this argument fails because, as Mr. Henderson has forthrightly admitted, the comprehensive plan doesn't regulate building height. Only the LDC does. And on top of that admission in their, I believe it was the pleading where they voluntarily dismissed counts 1 and 2. On top of that, the plaintiff's own expert, Peter King, whose deposition was previously filed, he admitted in his deposition that the comprehensive plan doesn't address building height. So as a result, the change in building height just doesn't change the intensity under the comprehensive plan. So before closing, Your Honor, let me just talk briefly about the affidavit of Peter King that plaintiffs filed in opposition to the county's motion for summary judgment. Can you still hear me okay, Your Honor? Somebody is unmuted. Okay. Your Honor, the county and Riverstone filed a joint objection to plaintiffs filing the affidavit of Peter King. Can you still hear me?
Yes.
Okay, thank you. And there's two reasons why this affidavit should be disregarded. The first is that it's well settled, and I believe Ms. Russell alluded to this, it's well settled that party can't create an issue of fact with a later filed affidavit. That's, that's Hornbook law. So in his deposition, Mr. King stated that the settlement agreement is not a development permit. The settlement agreement doesn't change the density, and that the settlement agreement doesn't change the use. So Mr. King testified to all that in his deposition, and I believe our objection has that, again, those citations. I'm not going to take the court's time right now to go through them. But on those 3 points, Mr. King's affidavit attempts to create an issue of fact where he says the opposite. The settlement agreement is a development permit. It changes the density and it changes the use. And that's it's not permitted to do that, to try and create an issue of fact with a subsequent affidavit. And then the second reason why the court should disregard Mr. King's affidavit is an interesting doctrine that I didn't know had a name. The doctrine is called mending the hold. Oh, you've heard of it. I had not heard of this. I knew what the doctrine was, and nor did I know it came from like ancient Greek wrestling terms. But anyway, mending, for the record, mending the hold is basically you can't take one position at one time and then later shift your position. So apparently in Greco-Roman wrestling, this was prohibited. And so what we've got here with the King affidavit is on one hand, we've got Mr. Henderson, who's filed a motion for summary judgment saying that the settlement agreement is clear and unambiguous. But then he also files an affidavit from Peter King that says, no, the settlement agreement is subject to interpretation. Again, you can't do that. So I would just urge the court to steer clear of the Peter King affidavit. In conclusion, I would just ask that the court grant the county's motion for summary judgment. The settlement agreement is clearly not a development order under 163-3215. It doesn't immediately authorize development. The plaintiff's own expert witness confirmed this, and there really are no genuine issues of material fact. I would again ask that the court grant our motion for summary judgment along with attorney's fees and costs under 163-3215-8C. Thank you, Your Honor.
Thank you. I'll hear from you, Mr. Henderson.
Okay, so we're going to go ahead and address Nassau County's motion and deal with Riverstone's later because they do overlap significantly. Okay, well, let me address the Peter King point first because, what the defendants want to do here is in amending the hold, that's an interesting side story. But what they really want to do here is they only want to focus on Mr. Hainline's examination of Mr. King and ignore mine. But also, even during Mr. Hainline's examination, on page 103 of his deposition transcript, Mr. Hainline asked him, will you be providing an opinion on whether the settlement is a decision of such local government granting or denying an application for a development order? The answer is yes. And the question is, and what is your opinion going to be on that? The answer that the settlement agreement acts as a development order. And during my examination, which is on pages 109 through 117 of his deposition, I developed that a little bit further and tied into the language that Mr. Hines had cited, where the definition is not limited strictly to as he would have it, just the things that, but it references any other order that would have the effect of allowing the development of property. And one thing, if I could just share my screen briefly, because
yes,
I did not have time to put this to the table. And this is the only thing I'll share my screen for.
I'm having a bit of a trouble understanding him.
It's starting to become garbled. Like if someone's on a cell phone and you say you're breaking up, it's doing that off and on.
Okay, I'll trust the technology will work.
Or a little bit more slowly, maybe. Is it allowing you to
I'll
share?
try that. I'll try that. So what I wanted to refer to was, in fact, why don't we, if Your Honor has, do you happen to have section 380.04 of the statutes in front of you?
Where would
If not, I'll share my screen.
You could just share your screen.
Okay. All right. Let me try that.
Somebody else has their phone
Okay.
not muted, Mr. Henderson. I think it's Pamela F. There we go.
Okay. Can you see that on your screen, Your Honor? The statute. So Mr. Hines was quoting from section 380.041, which contains the definition that he recited. We did refer to was subsection 2, which says the following activities or uses shall be taken for purposes of this chapter to involve development as defined in the section. And in particular, if you look at subsection B, it talks about a change in the intensity of use of land, such as an increase in the number of dwelling units in a structure or on land, or a material increase in the number of businesses, and so on. So that is directly relevant to the testimony from Mr. King that we recited in our response, relating to the adjustment to the density of the property. But so in terms of the authorities, we cited two cases in particular, or actually three, but the two that I'm going to refer to Your Honor to, there was the O'Neill decision out of the first DCA and the Graves decision out of the fourth DCA. And you recall that in O'Neill, you had a situation where, the O'Neill court talks about how 163 is broadly construed. It talks about how there was a concept site plan that was reviewed. And in this case, the plaintiffs waited until there was a later approval of a more detailed site plan. And their petition was dismissed as untimely because the court ruled that the earlier conceptual site plan was sufficiently enough to trigger a review of a development order. And so by their waiting until the more detailed one later, they waited too late. And that's very revealing for what we're talking about here. But if you look at that case at pages 705 and 706, when I provided the case to you in our bench notebook, it talks about, development is broadly construed and includes any building activity or change in the intensity of use of land, such as an increase in the number of dwelling units. So this is, so basically the idea being that if you wait for the more detailed order, you may be waiting too late. And in fact, if you look at Graves, on the other hand, in Graves, you had, the city in this case was saying, well, wait, this is, instead of saying it was too late, they said it was premature. And in Graves, which is out of the fourth DCA, 2011, it talks about how there must be a liberal interpretation of Chapter 163 must be given. It's that indeed the list of development permits contained, and this was, what Mr. Hines was quoting earlier, in 163.31.64.8 was not meant to be exhaustive, and it was followed with the language or any other official action having the effect of permitting the development of land. And significantly, the key language here is on the last page of this opinion, at the very last paragraph. The court said, in conclusion, 163.31.64 does not suggest that a development order is one which grants development rights only in the advanced stages of the development process or to a shovel-ready project. As the appellants maintain, and we agree, the city's approval of the revised plat grants PPI the right to develop the subject property in accordance with the uses or restrictions listed in the plat notes. So, and this was, in doing so, the court rejected the city's position that the challengers needed to wait for the approval of a site plan and the issuance of development permits. The court said that was not necessary. So let's refer then to the testimony that Mr. King did provide, including his deposition testimony that I referenced earlier, but also his affidavit testimony. In paragraph 11A of his affidavit, he refers to the provision on the Exhibit A to the settlement agreement to the arbitrary 100-foot buffers, and how that affects the future development of the property, and the fact that the beach access boundaries. This is let me go back. I'm sorry. The 100-foot buffers was addressed in his affidavit in paragraph 11 sub A, and it was addressed in his deposition on pages 79 to 81. Secondly, he addressed the beach access boundaries have being arbitrarily predetermined, and that's referenced in his affidavit in paragraph 11 sub B, and in his deposition at pages 93 to 94. He talks about how the settlement agreement grants up to 150 residential units in perpetuity, and how that is effectively grants development rights, and that's in his affidavit, paragraph 11C, and in his deposition at pages 110 through 117. And finally, he references to the fact that the settlement agreement deems the road frontage is deemed sufficient, and how that it effectively allows the development in ways that perhaps would not otherwise be allowed, because most property owners don't walk into a plan review with an advanced stipulation that however they want to carve up the property, they meet road frontage. But the effect of this settlement agreement we submit is that, you look at the paragraph 9D, I mean, it says in so many words, it says the property shall be deemed to have sufficient frontage and access along First Coast Highway to satisfy all comprehensive plan, code of ordinances, and LDC requirements for the development of 150 residential units. And again, at this point in time, we don't know how they're going to carve up the property. So how can we make the determination that it meets all those requirements? And this is in paragraph 11 of 11 sub D of Mr. King's affidavit. So I believe that this was the extent to which the development order definition, as I understood Mr. Hines' argument, was their only grounds for challenging count 3. So unless I missed something there, I think I've responded to his argument, and so I want to stop there and not get into any further argument that might not be necessary at this point.
Thank you so much, Mr. Henderson. Ms. Russell, I understand your client's not a party to this, but did you have anything you wanted to say?
Your Honor, thank you. I'll be responding.
Yes, thank you.
I recognize that the hour is late and you have a hard stop, and I don't want to expend any grace the court might allow me this evening at this early stage of the hearing. So I'm going to stand on the defendant's objection to plaintiff's summary judgment evidence and register my agreement with Mr. Hines' argument in that regard. Otherwise, Your Honor, of course, I'll be making arguments in support of Riverstone's motion for summary judgment that will speak to some of the matters that were argued by the county. I don't expect that the court will rule on Mr. Hines' motion before I argue Riverstone's motion for summary judgment. So with that in mind,
I'm not going to do that.
I'm sorry?
I will not be doing that.
Yeah. So I didn't expect that you would. So respectfully, I would defer any comments that I might otherwise make that would be pertinent to the county's motion until I argue on behalf of Riverstone's motion for summary judgment.
Understood. Thank you, Mr. Franklin. Mr. Hines?
Very briefly, Your Honor, just four points in rebuttal. The first, I did not catch the page and line that Mr. Henderson was referencing in the Peter King Depot, but if the court intends to hang its hat on that, my recollection is that what happened in the deposition was that Mr. Hainline elicited some pretty damaging admissions on direct Mr. Henderson asked a battery of leading questions to try and rehabilitate him. Each of those questions was what met with an objection, and Mr. Henderson did not rephrase at that point. So I would just ask the court to view those answers in that light. The second point is with respect to 380.04, which is our tab A4. Mr. Henderson points out section 2 of that and says that the definition is broader and includes a change in the intensity of use of land. Well, I went over that on my initial. It doesn't change the intensity. And then the second part of 380.04 to B that Mr. Henderson references, the examples of such as an increase in the number of dwelling units in a structure on land. There are no structures. Again, this goes back to the fact that 380.04 has those gerund phrases in them. You actually have to construct additional residences for it to count as a development under 380.04. My third point is to distinguish both O'Neill and Graves. In the O'Neill case that Mr. Henderson references, in that case, the parties agreed that a 2010 concept plan was previously approved was a development order. There's no such agreement here, so that issue wasn't even litigated in O'Neill. And then in the Graves case that he cites, in that case, the city code of Pompano Beach defines, explicitly classifies a plat, the filing of a plat as a development permit. And so that court found that plat approval has the effect of permitting development, but that was because the plat was defined in the city's code as a development permit. In this case, first off, we don't have a plat, and second, we don't have a code provision stating that plat approval is tantamount or equivalent to a development permit. So those two cases are distinguishable. Number 4, Mr. Henderson cited the affidavit of Mr. King. Again, the affidavit of Mr. King is problematic for the reasons I mentioned earlier. It's a late filed affidavit after a deposition. And that's it, Your Honor. See, the rest of my time I've asked that the court under summary judgment in our favor. Thank you.
Thank you. Anything further, Mr. Henderson?
With respect to the use or the alteration of the use and density of the property, that was really covered in Riverstone's motion, and so I'd like to address those arguments in context of responding to Riverstone's motion. So I don't have anything further to add, but to the extent that they apply to Nassau County's motion, I would like those arguments to apply over as well. But I prefer to address that in the context of Riverstone's motion, if that's okay.
I follow your thought process. Okay, so now let's talk about the clock. It's 5:47. If we move on to another motion, how likely are we to conclude argument on it in 45 minutes? Not very. Do you want to bifurcate and try to come back? I have lots of time available tomorrow and next week. Or do you want to just keep going? And when we get to 6:25, we'll figure out what we need to do.
Your Honor, I think I'm up next. I'm happy to keep going, but I certainly would defer to the court.
I just don't think we're going to finish the next motion in 45 minutes.
I don't disagree with that, Your Honor.
Does anybody have any objection to coming back tomorrow morning at some point?
Yep.
Is anybody unavailable tomorrow morning? Let me look.
Let me check, Your Honor. I'm checking.
And let me look to see what my JA has done about tomorrow. Let me look.
I am available tomorrow, Your Honor, tomorrow morning. Or actually, yeah, I guess I could do it in the morning.
Okay, so while I was out today, my JA moved almost my entire calendar, and she moved it almost all of it to tomorrow. So it looks like I'm open from 12:30 to 2. Does anybody have a conflict with that?
Your Honor, that would be fine with Riverstone.
Mr. Henderson, are you available tomorrow, 12:30 to 2?
I could make that work, Your Honor.
Is it better for you if we do that or if we look at Monday?
Let me look.
Why don't we do this? Why don't we go off the record for a minute to work on the scheduling, and then we'll go back and make on the record and make a record of what we've discussed. So 12, now we're off the record. 12:30 to 2 tomorrow is an option, but let's see if there's something.
That's fine with me, Your Honor, and I would frankly prefer just to plow through and get it done if we could tomorrow.
Well, tomorrow I have a hard
So
stop. I have adult drug court starts at 2. So, and I have hearings until 12:30. So I don't mind giving up the midday break, but that's what it is. 12:30 to 2. There's no flexibility other than that. Do you want that time, or do you want to just check out what Monday looks like so you know all your options?
we can look at Monday.
Let me tell you what Monday looks like.